Yes, it sounds.
Before I resume my submissions on 10.12, and can I just acknowledge that my Lord Justice Richards was correct about the transitional provisions, that it did automatically come into force. We see that from paragraph 13 at page 20, and so that makes sense of the fact that we maybe had a notice later. But it had already been bail had already been imposed upon him. So I apologise for not having properly picked that up before. And myself and Mr. Tam are in complete agreement about that.
Yes.
So just in terms of the follow-up submissions on the significance of 10.9 to 12, your Lordships will recall, going back to the judgment of the learned judge below, that. Which is at page 127 of the core bundle.
Yes, I'm going by the reported version in the Queen's Bench report. So,
right.
If you could
I'll give you a paragraph. So it's from 76 onwards.
That's helpful.
She addressed this issue between 76 and 79. She concluded that these provisions didn't undermine the construction that she'd adopted in terms of liable to be detained. She did accept paragraph 78 that paragraph 12A was not in itself an independent authority for detention, which is the submission we make. It can't be. It's got to refer back to the powers in the Immigration Act, and we would say that that is correct. But where we say that she fell in error is because she proceeded on the basis that this point of statutory construction could be addressed by practicality of bail, of not being detained but bail being reimposed.
Yes.
And we respectfully, and therefore she concluded that it didn't cast light on any proper interpretation of the statute as a whole.
Yes.
Right. So we respectfully submit, firstly, that whatever the solution to the situation which the judge accepted, which was that although 10.2 provides for the power to detain, 10.12 provides for the power to detain those who otherwise can't be lawfully detained, what she had to do, we respectfully submit, is apply the basic principle of statutory construction. You have to construe this statute as a whole. And as I've showed you previously, it isn't just in 10.9 to 10.12 that these provisions are there. They're integral throughout. There's recognition in the statutory scheme, as I showed you in 2.11, that bail is truly a conditional contingent release, and it contemplates at 4 that its bail can be revoked and you will be detained, and obviously then makes express provision for that possibility. And we respectfully submit that there is no way that the Secretary of State can construe 10.12, where it refers to the person is liable to be detained, anything other than lawfully detained if you're going to re-detain the person. And so construing the statute as a whole, making sense of this scheme as a whole, the learned judge can't avoid that application of basic principles simply by saying, well, if the person is detained because they may have broken the bail, the judge won't release them. And one reason why that can't work in any event is because 10.9 has already provided for the power of arrest and a period of detention before you've come before the relevant authority who could release you. So there has to be a period of time where the person is detained and can only be under the authority, if it's the Secretary of State who's granted bail, of the Secretary of State, which must mean under the provisions of Schedule 2 and or 3. So even if it were an answer on 10.12, which we submit it isn't, it doesn't address, and the learned judge doesn't with respect address, what's the position if the construction of this statute is as Mr. Tam suggests and as she found, for cases that fall under 10.9. And as I indicated to your lordships, previously this was a limited power for 24 hours. It's unlimited now. It may take longer, but of course, even if it were 24 hours, 24 hours of false imprisonment or unlawful detention is still significant, and obviously has important significance in the context of the court's approach to this statute and why liberty is directly engaged within it. Of course, my client remains at risk of that happening whilever he's on bail. So that's what we say in response to...
I'm not sure you need 10.9. I'm not sure that's really integral to your fundamental argument in this regard. It's 10.12a, which is, I think, central to your argument.
10.12a is because 10.12a makes it's up there front and centre. It says
what you say is you can't have a revolving door. That's what you're really saying.
Well, I'm saying you cannot. What 9 is important too, because...
Well, I hear what you say about it.
Well,
I think that you don't need it, speaking for myself.
Okay, well, maybe I don't need it, my lord,
consistent with... Sorry, forgive me, can I just finish
of course.
the point?
Sorry.
It could simply be a holding provision, because it uses the phrase, in the meantime.
Yes.
So that could actually... I'm not saying that you accept it, but it wouldn't really chip away at your fundamental argument, even if paragraph 9 is a freestanding power of detention. It is on its face only in the meantime. Yes. Your fundamental submission is that where the legislation says that you must do one of two things, one of them, in a Hardy-Singh situation, is actually legally impossible.
Yes.
And you say that casts some light on how the rest of the Act should be construed.
Exactly, my lord. And it does so also in the kind of soft law approach that the judge had to the conclusion, which is important to her reasoning, which is this is not a bail power, this is something new. Because it's that relationship between the ability to re-detain and the grant of bail or bail and detention that is at the heart of that provision, and which is at the heart of the classic notions of bail. So it was at its heart. It may have some additional elements, but it is at heart a classic bail power. Can I just make this one observation just about 10.9, which also would apply to 10.12, about the compatibility of these provisions with Article 5.1f. Because, as we know, the exhaustive conditions for the exercise of the power to detain under Article 5.1, the only relevant provision could be 5.1f, pending making the arrangements for deportation. And 10.9 power, in the meantime, before you come to the court, doesn't have a lawful basis in Article 5.1f. Obviously, nor would it have a basis if it was being detained because you've breached bail. That wouldn't be a basis upon which detention would be compatible with Article 5.1f, because it has to be linked to the immigration power to deport or to remove. And obviously, and there's no difference in approach between Article 5.1f cases and the Singh principles. So even if you were to conclude, which we respectfully submit, we invite you not to, that the statute was sufficiently clear to have achieved that purpose and created effectively a new power to detain, utterly disconnected from immigration enforcement, it wouldn't be compatible with Article 5.1f in any event. I don't know if I need to show you the cases, or whether, I don't think it's in dispute, that the case law is clear. JN is the Strasbourg authority that says Singh endorsed as lawful the domestic approach to detention, rejecting the need for a time limit because the Singh provisions were in place. So that's our submission on that. And of course, we also do make the submission, and I've showed you the case of Ismail and Zamir, that for Article 5.4 purposes, if you're in the category of case of somebody who can't be lawfully detained, simply putting you on bail is not a sufficient remedy for the purposes of Article 5.4. That's clear from those cases. It wouldn't be a sufficient remedy for habeas corpus either, although I accept if the statute does that, then it has overridden that fundamental hallowed provision of our common law. Parliament could do that. We say it hasn't, it could, but it can't do that in the context of 5.4, because if you're unlawfully detained, simply being released on bail, because bail is understood in the same way in Strasbourg as it was in the common law, as predicated on lawful detention, it means you haven't actually been released. You're still detained within the eye of the law. That's the old phrases from the common law, but it's the same with Article 5.4. Habeas and judicial review are an adequate remedy because they can order your release. Bail is still contingent. It's conditional. Your liberty is still a contingent, and it can obviously you can lose it if you breach conditions. It's truly a conditional, contingent form of, inverted commas, liberty, which isn't good enough when it comes to detention, which is otherwise unlawful. So that's why we respectfully submit to the judge was wrong to say it didn't cast light, and why it was wrong also, we respectfully submit, not to address, as she did at 83, the Article 5 issues. It wasn't good enough with respect. It wasn't a correct approach to say, well, we don't have to look at Article 5 because this is not a deprivation of liberty case. This is a case where we're construing these statutory provisions, and there are points that I've identified where these statutory provisions, if they were to be interpreted as the learned judge did and as my learned friend contends for, they would be incompatible with Article 5.1f and 5.4. And that is a circumstance in which this court can use its Section 3 powers. If on the face of the statute it's not compatible, it needs to be read down consistently with Section 3. And on the face of it, in my respectful submission, I've identified at least those two ways, 10.9 and 10.12, where there would be detention in the meantime or the breach of bail that would not be within the terms of Article 5.1f. And in a case where the detention was unlawful, you wouldn't have provided the adequate remedy that 5.4 provides. So that's why we say the learned judge was wrong in the way in which she approached these critical provisions. We also do, with respect, say that her starting point on the approach to construction was also incorrect. And you will have seen that the learned judge at paragraph 67 onwards identified as the key starting point for her approach to statutory construction the case of Barrias, relying on the principles set out in Bennion, where if Parliament has identified a settled meaning for a particular phrase, then there's a presumption that Parliament has also effectively reenacted that phrase. That was her starting point, and then of course she relied upon Kadir, and at 69 concluded therefore that in using liable to detention in this context, it was therefore meaning the same as the House of Lords had ruled in Kadir. And what was obviously critically important to the choice that the judge made of where she started on construction was the legislative history and the facts of the introduction of Section 61 following Court of Appeal judgment in B, and then obviously the implications of that as an attempt to overturn that judgment retrospectively. We respectfully submit that that was an approach that was based on looking at the purpose and the policy of the Act, as opposed to the proper starting point, which should have been the language of the legislation. And we respectfully submit that in that context, it's clear that the court is not concerned with what was the subjective intention, motive or purpose of Parliament, which have been some of the discussions that we've had today. I understand why the court wants to do that, to understand what the mischief was as it was. But it's not the starting point. The starting point has to be the meaning of the words, and those words that have been used. The relevant provisions of Benyon are in tab 80 at page 2074 to 6, and they quote in particular the Spaff Home decision. If we can just turn those up, they're in tab 80 at principle 8.8. On page beginning at 2074, and I'm sure this will be familiar to the court, but since it is important to this case, I'll just remind the court of what those principles are. And it begins on 2074, 8.1, and then if we look under the heading legislative intention, critical paragraph under 8.8, the legislative intention is the meaning attributed to the legislature in respect of the words used. And then there's the quote at the bottom of 2075 to this well-known Spaff Home case. We have that in the bundle at tab 27, but if I can, for speed, ask the court to read that extracted paragraph. It's the key paragraph. It's paragraph 27 on page 464 of the authorities bundle. And I'd also ask the court to read the extract from Lord Reen in the Black Clawson case, beginning, "We often say." And finally, at 2079, the distinction between legislative
well, forgive me. Obviously, Lord Reed is undoubtedly right, but taking that together with what Lord Nichols said, and the Supreme Court has opined on this in many cases, in very recent cases, it is not simply a linguistic exercise. Of course, we are seeking the meaning of the words used, but the meaning of the true meaning of the words used is to be found in the context and having regard to the purpose of the legislation, not purpose in the subjective sense of individual members of Parliament, but on the understanding that a piece of legislation is not done for the sake of it.
No, of course not.
What any legislature is doing is trying to achieve something. That's why it enacts a piece of legislation. So one is trying to give effect to the purpose, objectively understood.
Yes, and that's the key issue. It's not the subjective intention or purpose of Parliament. It's what have they achieved by reference to the words that are used. And all I'm saying, of course, it's just the starting point. And I'm not saying that there aren't other principles of construction. I've already showed you one which is relevant. Does it result in unworkability, or should it be construed as a whole? Obviously, those are additional principles. But I think in this context, it is important to start from the focus of the language, which obviously I've spent some time on. And in this context, it's not just what the language, what meaning you can derive from it. It's obviously also, does it meet the requirements of being sufficiently express and clear because of the implications of it. But then when one looks at the principle that the judge treated as the primary principle, which was the Barrias principle, if I could just make some submissions on that. It's
Can
referred
we put Benyon to one side now?
we can, if we can leave it open for one moment. This principle is at 24.6, and that's at 2126 of the same tab.
Yes, thank you.
And the substance of it is on 2127. And you'll see under the comment that it is a starting point, and there's reference to the case underneath, below, and that it's the same word or the same phrase in a similar context.
Yes.
And you'll see at the bottom of 2127, having quoted from the case of ZH and CN, Lord Hodge, this seems to mark a change in emphasis. Rather than giving rise to a presumption that Parliament has approved or adopted this meaning given to a word or phrase, previous judicial construction is simply part of the legislative history and legal context from which the courts may draw an inference as to legislative intent. No matter how the principle is characterised, it is clear that there's no rigid rule that words in an act must be given the same construction as the courts have previously given words in another act. Varying weight will be given to previous judicial interpretations depending on the context of each particular case. As Lord Hoffman said in Hoare, the value of such previous interpretations as a guide to construction will vary with the circumstances. The likelihood that Parliament intended to adapt to previous judicial may be greater where the earlier decision is well settled or well recognised. And then you have reference to the Belhadge case, where this was recently considered by the Supreme Court, and I'd ask the court to read paragraph 19 on 219.
Yes.
So it's no more than a presumption, and if you see at 2130, that previous, if it's erroneous, then obviously it won't be overruled. Obviously, for the purposes of this case today, I accept that Kadir is binding on this court, but we do reserve our position to argue differently in the Supreme Court. But what our primary submission here is, and we can turn up Kadir at tab 5 of the first authorities bundle, and making the submissions we make as to why it doesn't bear the critical importance that the learned judge below put on it. Is firstly because it's obviously an apparent, it was considering a power to temporarily admit and was not considering a power to grant bail or impose conditional bail. And we've seen how Parliament had previously made a significant distinction between liable to detained and detained in the previous legislation, and we see how the Supreme Court in B similarly made a significant distinction and didn't read over the Kadir approach to what's lawful, liable to be detained, or lawful detention into the bail provisions. And we say they were correct to do so, not just because the statute made a distinction, but because they are significantly different concepts and have significantly different implications for those who are subject to one of the regimes or others, or other regimes. The key paragraphs in the judgment of Lord Brown are at 31, and it's clear from 31 to 33, and the court may well have read these paragraphs. If you need to read them again, could I ask you to do that, and then I'll make my submissions?
I'm sure we have.
We have. I'm grateful. And what we say is that this analysis rested upon was, of course, construing a particular provision, temporary admission, but was also based upon a distinction between the existence of the power to detain and the exercise of it. That's picked up at paragraph 31 from the judgment of Lord Justice Mance in the Court of Appeal, and then emphasised again at paragraph 33, where the judge, where the court made the distinction between the Hardell-Singh line of cases, which is about the exercise of the power to detain, where properly it can be exercised and when it cannot, nothing about its existence. And then made reference to the Tam T. Lam case, which was said to be an example of a no power case, which on the facts it was. Although it was always decided, that case, under the Hardell-Singh principles. There wasn't a separate principle. It was the first Hardell-Singh principle in truth. The Tam T. Lam case was you weren't being detained for the statutory purpose if you couldn't be removed at all, or else it would be an example of 2 or 3. So it's important to recognise that Tam T. Lam is one facet of the Hardell-Singh principles, not a separate facet. And obviously what's important about this approach is that it is pre the judgment of the Supreme Court in W.L. Congo or Lumber, where that distinction between the existence of the power and the exercise of it was addressed explicitly, and in the context of a detention power, concluded that there was no distinction in terms of the impact. It was a decision where detention was couldn't have been exercised lawfully or wasn't exercised lawfully would equally be a nullity, just as it is if there was never any power. So that pre-anisminic distinction was not carried over, and it was rejected in the context of those claims for false imprisonment. And I know my Lord Justice Singh will be familiar with that case. It is in tab 44 of the authorities, which I think will be in your volume 3.
Two.
Yes.
And the key paragraph, which is off-cited, is in the judgment of Lord Dyson, at paragraph 66, applying the seminal anisminic case to the context of detention and concluding that cases where there's no jurisdiction in the narrow sense, this is at the top of 1054, paragraph 66, 275 of the internal numbers, or because such jurisdiction was wrongly exercised, both species of error render an executive act ultra vires, unlawful, and a nullity. And then we know the reasons why if a court can read that. So any distinction that was previously made in the case of Kaitey, albeit of course I accept in the different context of temporary admission, can't be read over to circumstances where it concerns detention. And we respectfully submit should not be read over to circumstances where you're concerned with bail, which has within it, for a significant number of people, that they will have been detained, and or they are liable to detention under the provisions if they breach bail. So that critical distinction that was made by Lord Brown in Kaitey doesn't read over to this context, in my respectful submission. And Lumber we rely on for that proposition.
He's not saying, is he, there is no distinction between cases where there's no power to do something and cases where there is power to do something but it's not been properly exercised. He's saying that in this context, which is whether detention is unlawful, it doesn't matter which flaw there is.
Yeah, I accept that. That is what's being said.
Theoretically, they are obviously different things from saying there is no power that exists and there is power, but it would be wrong to exercise it in these circumstances.
Well, theoretically, yes, and obviously prior to Anna's Minnick, there was a very significant consequence. Post Lumber, for the detention context, there is no difference. Both are a nullity. Both will mean that the detention is A, unlawful, and you would be entitled to
Damages.
Potentially for release and damages. That distinction, which was critically important in the judgment of Lord Brown, has to be looked at in the context of subsequent case law, which I accept is concerned with detention, just as Lord Brown was only concerned with temporary admission. But we are here in a different category of bail. And the importance of the B judgment in the Supreme Court is it makes it clear you can't allied temporary admission with bail, because they are two distinct categories of control over the individual. One is very much more intrusive than the other, and it's why the court said we're going to apply the same principles of construction as we do in detention to this bail provision.
Well, you really made that submission already.
Yes, I'm sorry.
No, that's not a criticism. Conceptually, that's the fundamental distinction you're making, is between bail and, for example, temporary admission. Speaking for myself, I'm not sure that paragraph 66 of Lord Dyson's judgment in Lumber is either necessary to your submission or sufficient to support your submission.
Well, it goes to the fact that as far as the judges, as far as we're concerned with reliance on the Barrias principle,
yes,
we are looking at a provision that has got a settled interpretation in similar contexts. So we say, one, it's not a sufficiently similar context because of those distinctions, and two, it isn't settled law for the point of the different concept of bail. We say the law that's settled on bail is the case of B, because that's what it was about, and that's the distinctions that were made.
Yes.
But that in any event, if we're looking at that core distinction that the court had in mind, it recognised that there was going to come a point at which you couldn't continue to say that someone was liable to be detained. It chose, for the reasons that it's explained, the circumstances where the power doesn't exist. So is that choice the right choice? And it was a choice because obviously the Court of Appeal and the High Court had come to a different conclusion under the temporary admission provisions. Is it the right choice in the context of a very much more onerous, restrictive conditions of bail? And we say that Barrias principle does not get you home in the way that Malone Friend advanced and the judge accepted. It's much more constrained in terms of its relevance, and it was key with respect to her judgment. And can I just make this observation about the Hardell-Singh principles, because it's clear that in Lumber the court treated the Hardell-Singh principles as an implied restriction on the power to detain. And I won't take you to that now, but that was part of the analysis. It's a construction point about the scope of the legislation as well. They're implied limits, and even Lord Brown in the dissent recognised and put the Hardell-Singh principles into the category of error that would have given rise to a claim for false imprisonment. And your lordships will see that his judgment begins at 347 on this point. He was in the minority, but he attempted to seek to categorise which errors of law would constitute unlawful detention. And you'll see at paragraph 347 below G, under the heading detention beyond the scope of the detaining power similarly constitutes false imprisonment. For example, the limitations imposed by the courts following Wolf J's decision in Hardale Singh undoubtedly operate to constrain the power of detention under paragraph 2 of Schedule 3, and it has long been recognised that detention in breach of Hardale Singh principles gives rise to tortious liability. I recognise may not always be easily distinguishable. But the first Hardale Singh principle constitutes a precondition for the exercise of the detention power. It seems to me nonetheless worth attempting that distinction. So when he came to look at the categorisation of the Hardale Singh principles, he didn't put it fairly and squarely in the context of it's about the exercise of the power. He recognised its significance in terms of going to the existence of that power, because it was part and parcel of the construction of the implied limits within that power. And so I don't ask the court necessarily to say you've got to decide this point. The question is there settled authority that means that there's a very strong presumption that when the court used the word liable to be detained, it must have meant the Kadir approach. And for these reasons, we respectfully submit that wasn't established in this context. The construction principles are different. The Kadir House of Lords didn't apply the same approach that B has done to bail. You can't align the two, and it rests on a distinction that is now questionable in law, see Lumber, and the Hardale Singh principles themselves may well go to the existence of the power, at least some of them, not simply to its exercise. So this man, if he were to be detained now, nobody could say it would be for the statutory purpose of deportation pending removal, because he can't. It wouldn't be for the statutory purpose, because it's simply impossible to do so. Or you could also say it's not reasonable, but he is in the category of case now where you can't say the statutory purpose is being furthered, given the impossibility of removal.
Right.
So one other authority that we cite in the context of the correct approach to interpretation, and I'm sure it'll be familiar, which is the Privacy International case at tab 58.
Yes.
And I'd ask the court to read paragraph 153. Obviously, I accept it's in the context of an ouster provision.
Yes.
And so that puts it into a particular category where the court has obviously applied its strongest interpretive provisions against an ouster. But it does cast light on the approach in a not dissimilar context, where we respectfully submit we have a combination of factors that are in play here that all point very strongly against the interpretation that was accepted by the judge, which is liberty, legality, the fact that we are here, if it were correct, overturning a very long established law relating to bail and its connection and dependence on lawful detention, the impact on habeas corpus, and also obviously it would have the backdrop of Article 5, which obviously will be there in any event. But all of those factors in terms of common law presumptions, we say should have been the starting point, not the Barrios principle. And for that reason, the learned judge erred in her approach to interpretation, and should have concluded, in order not only to preserve those important fundamental rights, but to ensure that this was a system of bail that was going to be construed coherently and consistently across the whole statute, and didn't create unworkability of the kind that my learned friend's submissions would have resulted in if it had been the approach prior to the introduction of it, i.e. because you can't surrender to bail and or you can't be re-detained for breach of bail, that principle of unworkability also it supported very powerfully the submission that was advanced and which we asked to endorse in this court, that where the provisions say liable to detain, they mean liable to lawful detention. Lords, that's my submissions on ground 1.
Yes.
Ground 2, I hope I can take speedily.
Yes. Well, you must.
I have
the
to,
time.
yes. I've got to do it very speedily. So it's common ground that on the law that if the facts were that there was no prospect of removal, then the Kadir approach bites and my client wouldn't be liable to detention. So on the law, we're in agreement. We respectfully submit that the facts have now been found, which is why we seek to introduce the judgment of the First Tier Tribunal that dealt with an application to revoke, and if your lordships have, to revoke the deportation order, and if your lordships have that judgment, the key findings of the First Tier Tribunal on nationality are at 24 to 25. So they concluded paragraph 39 is the conclusion.
Yes.
Sorry, apologies. Paragraph 39, that the appellant is Guinean, that, and that's consistent with previous findings. It's common ground that there's no prospect of removing him to Guinea. We see that at paragraph 54, and then that's the finding of the court. To Ghana, that's 54. And then at 65, that because the appellant is in an unsatisfactory state of limbo and has no prospect of being resolved in the foreseeable future, the court concluded that the balance came down in his favour. Sorry,
what was the last paragraph?
My lord, it's paragraph 65.
Thank you very much.
And so we respectfully submit that the interests of justice and the overriding objectives clearly point to this court grappling with this question. We have set out in extensive detail, which I don't repeat, why we say this point was fully argued below, and the transcripts are the most important evidence because they make it clear that Mr. Goodman advanced the argument, and in fact my learned friend responded to it. If your lordships had the opportunity to look at the transcripts, then you'll see that it was clearly argued. We respectfully submit that the grounds of appeal were wide enough in ground 1 to cover this point. It's a point of construction that the court needs to address because it's got to grapple with the two alternatives. Is it Hardale Singh unlawful, or is it Kadir unlawful? So the court is bound to have to deal with that issue in deciding one way or the other who is right about that. And if it's clear, as we respectfully submit it is now on the facts, we said it was clear below. But in any event, now it's put beyond doubt because there's a finding of the First Tier Tribunal which the Secretary of State, although she seeks to appeal elements of it, doesn't seek to challenge those underlying facts. Then in those circumstances, justice and overriding objective points to this court dealing with that matter. The law is agreed, and the facts are now determined by an independent tribunal that the Secretary of State doesn't go behind. The alternative would have to be beginning this case again, and another judge, another application, another judges having to deal with it. And so there's clearly a powerful reason why this court ought to do that.
Another possibility is that you make these points, they make a fresh decision, and they accept what you're saying.
Well, the Secretary of State has had that judgment since June and could have avoided this discussion that we're having now if that's what the Secretary of State was going to do.
No, all I'm saying is that it doesn't necessarily require the intervention of this court. It might be said that as a matter of principle, this court should not intervene because the fundamental question for this court on an appeal is whether the lower court was, quote, wrong, unquote.
Yes.
And at least the starting point, not always the finishing point, is that we decide that question on the material which was before the lower court.
Well, yes, I accept that, but my lord, this is circumstances where, unusual circumstances, where the material that we seek to admit is findings of a court in which we're both the same parties, which the Secretary of State isn't seeking to appeal and is binding upon her. And so we do respectfully submit that that is a different position than simply trying to provide new evidence.
Yes.
It's a judgment of the court that is binding. And
Can
so
I-
for those reasons, we respectfully submit that, certainly binding on the Secretary of State, obviously not on this court, for those reasons, there's a very straightforward route through this case. There's no disagreement on the law, and we respectfully submit there's no sensible disagreement that can be had on the facts now. And one thing that one can say about this case is that it ought to have resolution as speedily as possible of this man's position. It may be that the FTT decision will resolve that, but there is an appeal on the approach of the law. But this court can say now, applying the law as the Secretary of State says it is, to these findings of fact, there's only one answer, and therefore we ought to make it clear that that on whatever view, whatever liable to detain means, it doesn't apply on this man's case. So that would be our submissions. We do submit that on the evidence below, the position had already been reached. But I'll put my case on the basis of the high point, which is now we have categorical findings from the court. So I'd ask you to grant our, if we need it, application for permission to appeal and to admit that
Yes.
judgment.
I think my lord had a question.
I just had a question. I wasn't entirely sure whether your submission was that the FTT had found as a fact that there was no prospect of removing him to Guinea. That's what you initially said with a reference to paragraph 54. But
To
you
Ghana.
then to Ghana.
Yes.
The position with Guinea, as I read it, is that the FTT found that there was no prospect immediately or in the foreseeable future of removing him to Guinea, but did not find that there was no prospect ever of removing him to Guinea. Is that right?
I think the position of the Secretary of State has been since 2016 that there's no prospect of removing him to Guinea because Guinea refused. So the Secretary of State then raised the possibility of removal to Ghana, and that he may be a Ghanaian citizen because of some what we would submit as pretty flimsy evidence, or not even evidence, but assertion. And so,
Well, I understand your position.
So the Secretary of State accepts that, and Ghana's not an option. So therefore, there is no prospect of removing this man. I hope that that's clear. My lords, then I'm going to leave ground 3 to my learned friend.
Yes.
Ground 4 I can take very shortly for this reason, which is it is, in my respectful submission, for the Secretary of State to show you, and she'll have to do so, even if we're wrong, because of the Kadir position, what does happen to an individual who has been, who is no longer liable to be detained, on whichever basis the court comes to.
Yes.
And we say that in those circumstances, it is a question of statutory construction. This is a comprehensive statute. It provides for now only 3 categories of status, either detained, immigration bail, or leave to enter. And so if you cannot do either of the other 2, the
Yes.
only option under the statute is leave to enter. And we certainly would submit that what the court, it's a surprising submission for the Secretary of State that he simply wants to say, I want to leave this person at large, given that the person has been subject to conditions, at least of residence and reporting, so that the Secretary of State knows where that person is. And of course, in some respects, being simply at large in the hostile environment is even worse than even at least having bail. You're still in the limbo situation. It's limbo plus, because you've got no state, nothing at all, nothing that governs your residence in the United Kingdom, and you're subject to all of the extreme conditions that have been implemented because you have no status. including the ones that I've said. So it can't sensibly be the case that having got to the point, the liable to no liability to detention, you're going to put yourself in a worse position by having reached that, what was likely to be quite an extreme threshold, 10 years as in this case, could be longer, as we see in the evidence of bid. And so in my respectful submission, there's both a lack of legislative basis for at large, and there are very powerful reasons why you wouldn't simply put that person at large once they've reached that extreme position. And that would be the case whether it's Singh removal or the Kaitey removal. We did indicate in opening that the alternative way in which we put our case is that certainly in Kaitey, the court proceeded on the basis that there would come a point at which it was no longer reasonable to continue on temporary admission, and all that was contemplated in Kaitey would be that you would be given some form of leave. That's in the judgment of Baroness Hale at paragraph 4. And I should just say that there is a decision that we've relied upon of the upper tribunal in the case of AM, and I'll just give you the reference. And the upper tribunal has concluded, under its president, that if you reach that backstop position, then it is leave to enter that has to be granted. It's in tab 60. But
we can't grant leave. We're not the Secretary of State. Well, I think what you're saying is that if there is only one rational outcome available
yes,
to the Secretary of State, then this court should make a declaration to that effect.
yes. If our first argument is correct, and there isn't, the statute only provides for these categories of status, then it's by dint of the operation of the law. Otherwise, it's about the exercise of discretion. And again, I agree with your lordship that would be the position. Just in terms of the AM case, I should just indicate to the court that permission has been granted in that case. I know there's an appeal to be heard by this court in January. But as it stands at the moment, the Specialist Tribunal has concluded that the only option is the grant of leave once you've reached the position where there's no prospect of removal.
Now, can I just be clear? This is not a freestanding ground of appeal, as it were. It depends, does it, on your succeeding either on ground 1 or on ground 2?
Yes, they're interrelated. We only get to that point if we've reached the limits of lawful detention, either Singh or Kaitey.
Thank you very much. Right. Well,
those are my submissions.
thank you. May I just check if my lords have any?
I did have one question.
Yes, of course.
I'm probably missing something very, very obvious, but the Nationality Act in 2002, by Section 67,
Oh yes, yeah.
says that this applies to any provision which refers to someone who's liable to detention under the Immigration Acts. Does Section 67 apply to the phrase liable to detention in the schedule to the 2016 Act?
I need to check that.
It's at tab 14 of the first
Yes.
volume of the authorities.
It's still in force, so it does apply to
It does.
it.
Okay, I haven't seen it. Okay. Well,
Page 236 in tab 14.
sorry. Yes.
And it says the section applies to the construction of provision which B refers in any terms to a person who's liable to detention under the provision of the Immigration Acts. My understanding is that this section is still in force. So
Yes, that's the position of. Yes, but the limitation on it, which is why it wasn't used to any effect in the B case is in 67(1)(a). It does not confer power to detain a person. So we know that the provisions under Schedule 10 do confer a power to detain, because 10.9 and 10.12 do. So it is limited
but it's
to
a
temporary admission.
provision, not a schedule. So the question is, the provision we are construing
Yes.
is not paragraph 10 of Schedule 10. It's paragraph 2, 1(2) of Schedule 10. The Secretary of State may grant a person bail if the person is liable to detention under, and then there's a number of provisions. So the question is, my question is, does Section 67 of the 2002 Act apply to the construction of paragraph 1(2) of Schedule 10?
My submission is that it doesn't, because you have to construe those provisions as a whole, and you would have to construe it also for 10.9 and 10.12, which provide for a power to detain. So you can't, or else you're going to have a different interpretation in Section 1 or 1.5, as you might have for sections 10.9 and 10.12, which would then lead to unworkability. That's obviously not what was intended, and difficulty that will arise. So that's why we say this provision is limited to, would be limited to temporary admission provisions, which is what it was specifically implemented to address.
Well, obviously, in 2002, what is now Schedule 10 didn't exist, so it wasn't
Correct.
directed at Schedule 10.
No.
But it appears to be forward-looking. I mean, it's not just construction of existing provisions. It appears to apply to provisions at any stage, including subsequently enacted provisions, which are concerned with this, with whatever it's concerned with.
But yes,
Yes.
with the caveat that it cannot apply to provisions that provide for power to detain.
Forgive me for interrupting you. This was considered in Kaitey, wasn't it?
Yes.
And Lord Brown said that it hadn't been necessary.
It wasn't necessary, exactly.
But when it was enacted,
Yeah.
Parliament had thought it was necessary to reverse the decision
Yes.
of the first instance judge.
Yes, that's right. So similarly, yes, that's exactly correct. But it is obviously, on its face, limited in the way that I've emphasised.
Yes,
And
and-
it could have been a complete answer to the case in B. But it wasn't, because again, it didn't relate. And obviously, it was before the court. We were all aware of it. It's not the complete answer, because it's caveated by not applying to powers that relate to detention.
It's not a complete answer because B was not concerned with a person liable to detention.
Yes. That was one of the points made, but in B, paragraph 13.
Yes, it's true. That is true. Yes, it's slightly circular, but ultimately there is a distinction that's made.
Yes, no, I understand.
Because it was only concerned with that power of temporary admission, which has now been repealed. Right. And we would therefore respectfully submit that it doesn't provide the answer here. If you're going to find the answer, you have to find it in clear, express words within Schedule 10. And for the reasons that I've sought to advance, you cannot find it with the requisite clarity necessary, given there's very substantial implications of this radical departure from what the previous position was. Right. And even if you were to, we respectfully submit that it would be incompatible with Article 5 for the reasons that we've advanced. Yes. My Lords, those are my submissions.
Well, thank you very much. Mr. Vidsky.
May it please your Lordships, it is grateful to the Court for its grant of permission to continue its intervention in this important case. My Lord, in the case of Daly, which concerned fundamental rights protected by the common law, Lord Bingham famously said that the rights at stake in that case could be curtailed only by clear and express words, and then only to the extent reasonably necessary to meet the ends which justify the curtailment. And that passage is quoted in unison, which you have in the authorities, at tab 53, page 1335. The present case concerns the right to liberty, no less fundamental than the rights under consideration in Daly. And the intervener's submission, in essence, is that the clear and express words needed to expand the bail powers in the sense for which the Secretary of State contends are not present in Schedule 10 of the 2016 Act. But in any event, the right to liberty may be curtailed by the bail powers only to the extent reasonably necessary. And our alternative submission concerns implied limitations. And my learned junior has just handed up a note which is intended as a roadmap to BID's oral submissions and to speed those by supplying references. May I apologise that unfortunately we seem to have a different authorities division to the other parties, and therefore could I ask you to ignore references to volumes and look only to tab references and page references, and the same unfortunately applies also to our skeleton.
All right.
BID's submissions are organised under 4 headings. To avoid duplication, I propose to spend most of our time on submission D, that's BID's alternative submission concerning implied limits, which has been left to us to develop.
Yes.
And I don't propose to address you at all on the question of ground 2, which is of course fact specific, or ground 4, as to which we simply rely on the matter set out in our skeleton. Turning to the first heading, A, my lords, the underpinning for both BID's primary and alternative submissions concerning the scope of the bail powers is that these must be construed according to the same principles, the strict and restrictive statutory construction, as detention powers, in light of their potential to severely curtail individual liberty. And BL jury is, of course, the highest authority for that proposition. May I address a point that was raised by my Lord Lord Justice Singh this morning, which is, to what extent does this depend on the facts of the case? And we say that for the avoidance of doubt, Supreme Court in BL jury was engaged in an orthodox process of common law construction of statutory powers in light of the words of the statute, the context, and the impact of that statute in limiting fundamental rights protected by the common law. And that is not a fact-specific exercise in the way that, for example, a Section 3 Human Rights Act exercise would be. And we say that there is, here as in BL jury, a single correct construction of the limits of these powers. What is fact-specific is simply the question of whether those limits were exceeded in a particular case. And my Lord, we do say that the BL jury conclusion as to the application of the strictest principles of statutory construction here is fortified by the Supreme Court's conclusion in Jallow that a curfew in that case lasting 8 hours out of every 24 amounted to a common law imprisonment, therefore attracting the constitutional protection for tort of false imprisonment. And as can be seen from the facts themselves of Jallow, and also from the statement of BID's legal director, Mr. McLoof, at paragraph 12 of his statement, such curfews are in practice quite commonly imposed by the Secretary of State when bailing mid-level foreign national offenders. And in fact, that will now become all the more prevalent because a presumption in paragraph 2 of Schedule 10 that electronic monitoring should be imposed on foreign national offenders has come into force since August 2021. So that's a development since BID's skeleton. I'm now at heading B, the approach to statutory interpretation by Mrs. Justice Lange. And I shall pass over paragraph 3, which has effectively already been dealt with by my learned friend Ms. Harrison, and go on to paragraph 4. And we do say that there, while Mrs. Justice Lange below very rightly accepted that there was a need for a separate, careful analysis of the clarity of the statutory words, that analysis never quite took place. And rather, what happened was primacy placed, we say erroneously, on the Barras principle, but also on the legislative history and on Parliament's presumed subjective intention. May I ask you to turn up, please, Privacy International at Authorities tab 5, and it's a different point that I wish to show you from that already highlighted by Ms. Harrison. And the point is that at paragraph 111, I'm sorry, 106, I beg your pardon. And I'm sorry, I said I wouldn't refer to volumes, and I've made exactly that mistake. So it's tab 58,
Yes.
and it's page 1511.
Yes. Thank you.
And could I ask you to look first, please, at paragraph 106, which summarises the submissions of Counsel for the Secretary of State. If I could ask you to read that to yourselves, and then paragraph 107. And may I ask you also, please, to then look at paragraph 111. And we do respectfully say that the learned judge below did fall into the error precisely that's identified by Lord Carnwath of placing overwhelming emphasis on subjective intention to, that is, what did the promoters and supporters of the Act wish to achieve, to the exclusion of the key question of whether the words used were in fact sufficiently clear to achieve that result. And I'm turning now, please, to BID's heading C in our roadmap, which is the question of whether the clearest words were used. And for brevity, I shall refer to the broad construction as Mrs. Justice Lange's construction, and that for which the Secretary of State contends, and the narrow construction being that for which the appellant and intervener contend. And could I ask you, please, to have open both the judgment below, which is core bundle tab 11, and at the same time, please, the statutory provisions in question, Schedule 10, which are at tab 3 of the authorities.
Yes.
The analysis of the judge below, and I'm referring here to paragraph 74 of her judgment, was that paragraphs 1.1 and 1.3 of Schedule 10 allow the Secretary of State to detain two groups who are liable to detention.
Yes.
And in her analysis, 1.1 refers to those presently detained, 1.3 refers to those, whether previously detained or not, who are liable to detention.
Mm-hmm.
I'm sorry, I've erroneously said, I'm sorry, instead of saying 1.3, I should have said 1.2, I beg your pardon, 1.1 and 1.2.
Yes.
And on that analysis, paragraph 1.1 is OTS, functionally OTS. the judge then, at paragraph 74, still, says that 1.5 goes, in her words, somewhat further, by which she presumably means that 1.5a goes further than 1.2, because it refers to a person who has been but can no longer be detained. She states, paragraph 1.5 makes clear that the Secretary of State can also give immigration bail to a person who has been but can no longer be detained. But of course, this is not a provision that goes further on the judge's own analysis. Rather, on the judge's analysis, it refers to a subset of individuals liable to detention who've previously been detained and can no longer be.
See, I've been wondering about whether she was right about 5. On its face, it might be said that it includes the person who has not been detained in the past, but can no longer be detained. Why, as a matter of language, could it not cover that category?
My lord, I think the difficulty there is section 61.3. I wasn't intending to go to the old section 61.3, but perhaps I should, because it sheds some light here. And that's at tab 1 of the authorities, page 7. And of course, the Secretary of State's submission is that these are functionally identical. 1.5a and section 61.3 do the same job in Secretary of State's submission. And it's very clear that section 61.3 is referring to a person who has been detained. A person may be released and remain on bail, even if the person can no longer be detained. So, my lord, I should say, we don't in any way suggest that we can offer an entirely pellucid interpretation of these very contorted provisions. Rather, what we are seeking to show is the difficulties, at this point in my submission, the difficulties in the border construction. So we say, turning back to 1.5a, which is page 10 of the authorities, that there are key problems in this provision, which is so central to the border construction. Either it describes the position for a subset of people covered by paragraph 1.2, just those who have previously been detained, in which case, if it's a subset, 1.5a is functionally otious, or 1.5a actually circumscribes 1.2, it limits the circumstances in which a person may be released on bail who cannot lawfully be detained to a person who was previously detained. And if that's right, then 1.5a would not, of course, apply at all to a person in Mr. Kadir's position or to the classic temporary admission scenario, someone who's never been detained. It would not allow a person never detained to be placed on bail.
He was, in fact, detained at some point.
My lord, I apologise if I've made an error there. My understanding was that he was a port case who was simply granted temporary admission immediately, but I may have that wrong.
The judge is referring to Kadir, not to Alcott. I'm sorry, Kadir.
I'm sorry, and I'm referring to Kadir. I beg your pardon.
Sorry.
Your lordship.
I was misunderstanding your submission.
Oh, I'm sorry. No.
My fault entirely.
And on the broad construction, great emphasis, of course, placed on the phrase liable to detention, so that 1.2, as it were, can do all the work. 1.2 allows the Secretary of State to bail any person on the broad construction who can be lawfully detained in the foreseeable future, whether or not they are currently detained or capable of being lawfully detained at present. And that renders both 1.1 and 1.5a otious. May I apologise that I'm moving at such a pace, but I'm so keen to get to the alternative submission that I'm aware has been left to me. I am turning now, if I may, to 5C of the roadmap, the anomalous relationship on the border construction between the powers of the Secretary of State and those of a tribunal. At paragraph 72, Mrs. Justice Lane declined to determine the meaning of the words "is being detained under a provision" on the basis that the present case did not concern someone bailed from detention. But in our submission, the problem of what being detained under means is further indication of the lack of the requisite clearest possible words to underpin the broad construction. And the problem we say is as follows. We say the words is being detained but appear in 1.1 and 1.3 must mean lawfully detained under the specified provision. And that's so because of the applicable principle of strict statutory construction, and it's also in bid submission the consequence of the Supreme Court's judgment construing materially identical words in the bail context in B. Algeria. You already shown paragraph 31 by Ms. Harris, and I won't ask you to turn it up again, but if I can just give you the words of Lord Lloyd Jones there, who said, applying the strict approach to interpretation, which I consider is required here, those provisions must be taken to refer to detention, which is lawful. And we say here, where one is comparing like with like, the barrister presumption does bite with considerable force. So we do say that paragraph 1.3 of Schedule 10, referring to the tribunal's bail powers, only allows the tribunal to bail a person who is presently lawfully detained. That is, the tribunal's bail powers in 1.3 remain the same as those that were interpreted in B. Algeria. And that leaves a conundrum under the broad construction about what 1.5a means. Either 1.5a, when it refers to liable detention, liable to detention, I beg your pardon, refers back to the Secretary of State's bail powers in 1.2, so that 1.5a is only concerned with the Secretary of State's bail powers. If that's right, then on the broad construction, there is an unexplained disjuncture between the tribunal's powers and the Secretary of State's powers vis-a-vis a person who is currently in detention. On that analysis, the Secretary of State can bail a person who is presently in detention but unlawfully so, but the tribunal can only bail a person who is presently lawfully detained. So that's one analysis of 1.5a. The alternative, still on the broad construction, is that 1.5a applies to both the tribunal and the Secretary of State's bail powers. But that, we say, seems inconsistent with the structure of paragraphs 1.1 to 1.3, according to which one would have expected to see a provision which expressly conferred on the tribunal a power broadly equivalent to that of 1.2 to release people who are liable to detention. To conclude that paragraph...
If they're only liable to detention and are not in fact being detained, why would a tribunal get involved at all?
I'm sorry, I'm not suggesting that the tribunal would be involved for people who are not currently in detention. My point is, if the tribunal's powers extend not only to people currently lawfully in detention, but also to people currently unlawfully in detention, then one would expect some broad analogue to 1.2, saying something along the lines of the tribunal may release a person liable to detention who is currently detained, perhaps unlawfully so in brackets.
I'm afraid it's my fault. I'm being very slow. I find it all very curious because the tribunal may have no idea what the Secretary of State's practical position is, whether, for example, she's going to be able to get an ID document from the relevant embassy in time and therefore conform to the Singh principles of limitation of time and so on and so forth. But they may have no interest in that. They may think there's no good reason for this person to be detained, so we should grant them bail because, for example, there's no risk of absconding or whatever it may be. Are you saying that they would have no lawful power to grant that person bail, even though they think that's the right thing to do?
My lord, precisely that issue arose in B. Algeria with Supreme Court, where my learned friend Mr. Tam said, well, this is a big unworkability problem with the construction of a Court of Appeal, that the tribunal would have to decide, Mr. Tam said, whether or not a person was lawfully detained before it could grant bail. And the submission of the intervenor bail for immigration detainees and also of Mr. B in that case, which was accepted by the Supreme Court, was no, what the tribunal simply does is proceed to examine bail on the presumption that detention is lawful. And there is, in fact, I can turn it up in a moment, bail guidance from quite some years ago from Mr. Justice Blake, as he then was,
Yes.
to that effect. But the practical way around that conundrum is that the tribunal is told, presume lawful detention. But I feel I'm straying from the point, which is, what does 15A do? So either it applies only to the Secretary of State, or it also applies to a tribunal. And if it applies to the tribunal, and if the analysis is that 15A confers a new power on the tribunal, contrary to the Algeria, to release a person who is currently unlawfully detained, that would radically expand the tribunal's bail powers by unclear words, which don't even clearly refer to a tribunal at all. I would respectfully say it's not entirely clear, because Justice Lange seems to have thought it only applies to the Secretary of State.
Can I suggest to you what I put to Ms. Harrison and invite your submission? It seems to me that it is entirely apt to apply to the classic Hardy Singh scenario, where someone is, as a matter of law, liable to detention, but because they can't be deported within a reasonable time. So it might be that if we'd been able to deport them last year, they could have been detained. But we now know they can no longer be detained, because we now know that they can't be deported within a reasonable time, therefore they cannot be detained. They can no longer be detained. Why doesn't it apply to that situation?
My Lord, one of the points that we make, and this is particularly in light of the dicta in privacy, powerful dicta in Privacy International, is this is not a level playing field. So
Sorry, this is not a
level playing field, as it were.
Yes, I see.
So if we can show you a plausible construction, and so too can Mr. Tam, even if you are inclined to think that Parliament probably wanted to achieve what Mr. Tam says, the question is, did it achieve, by the clearest possible words, that objective? And we say no, because these provisions are so unclear and open to more than one interpretation. May I just turn to what interpretation BID offers? That may be the best answer to your Lordship's question. And I'm now at paragraph 6 of the roadmap.
Yes, thank you.
We say paragraphs 1.1 and 1.3 refer respectively to the powers of a Secretary of State and a tribunal to grant bail to persons who are presently lawfully detained, being detained following the usage in B, Algeria. So in the Secretary of State and Tribunal's powers of bail, we say, are aligned as concerns a person presently in detention. We say paragraph 1.2 then gives the Secretary of State an additional power to bail a person who's not presently physically detained, but who's liable to detention under those same statutory provisions. And in our submission, as submitted by the appellant, this means liable to lawful detention in the specified detention provisions. That is, the detention powers could now be exercised lawfully for that individual. And in BID's submission, the function of paragraph 15A is emphatic and clarificatory. Paragraph 15A clarifies that the fact that a person can no longer, for any reason, be detained does not preclude their release on bail, provided that they remain liable to lawful detention. So your Lordships may ask, well, what would that cover? And it would cover for a host of practical reasons why a person might, and policy reasons why a person can no longer be detained. A pandemic, a strike, a shortage of beds. There may be a situation where a person is liable to lawful detention now, but the appropriate course is to grant them bail. Or there may be a situation that arises, and for example, a Kambadzi type situation, where the Secretary of State could now lawfully take a decision to detain this person, but has yet to do so. For example, the Secretary of State has yet to carry out a lawful detention review. So we say those are, that is our analysis of what paragraph 15A can be understood to say.
Pick up on that last point. So my understanding of what you've just said is that somebody who could in principle be detained, but can't yet because the Secretary of State has to go through a lawful detention review before making that decision, would come within 15A?
We would say yes, because there's
Okay, can you explain to me why it doesn't say? I mean, that you would expect it to say something like, the person may be granted and remain on immigration bail, even if the person cannot presently be detained, but is liable to detention. Whereas what it says is, can no longer be detained, which points up my Lord's point. That tends to look at somebody who could have been detained in the past and now can't. And the obvious person who falls into that category is the Hardy Singh person, right? Where it's too late.
My Lord, our answer is simply that it is not for us to show the clearest possible words. It is for those, Mr. Tam, who are contending for the broader construction. And so my answer might be, well, why doesn't 15A, with respect, say more clearly, this allows the bail of a person who can lawfully be will lawfully be detainable at some foreseeable point in the future, but in respect of whom the detention powers cannot lawfully be exercised now. My Lord, that is our submission. But I do emphasise that it is not, as it were, a level playing field, and that the scenario envisaged in Privacy International, of course, legal history is replete with examples of situations where the promoters and supporters of legislation may well have intended a particular result, but didn't achieve it by the clearest possible words. And this, your lordships may consider that this is such a case.
I think speaking only for myself, I think that there are two different things going on here, and it may not necessarily be helpful to confuse them. I can well understand the submission that even if it's an artificial construction, even if it's not necessarily the obvious construction, a plausible construction which can be given to a statute must be given to it if that vindicates fundamental liberty, whether it's the rule of law in Privacy International or personal liberty in this context. And that can only be overridden by clear words on the part of Parliament. All of that I understand, but we keep hearing about subjective. I'm not sure that subjectivity versus objectivity has anything to do with that principle of construction. I think everyone accepts, Mr. Tam may disagree, but certainly for the time being, I'm prepared to proceed on the footing that the exercise of statutory construction is never a subjective one. You know, and that's why we don't allow, for example, members of Parliament to come to court and give evidence about what they intended. It's not relevant. It's an objective exercise, but it is an objective exercise in giving effect to the true meaning of what Parliament has said, read in its context and in the light of, let's not even say Parliament's purpose, let's say the purpose of the Act, because that's really what one is trying to do. But suppose objectively the court comes to the view that that is that's what the Act is trying to achieve, that this is precisely designed to deal with the Hardy Singh situation. What are we to do then?
My lords, if your lordships reach the conclusion that the clearest possible words are used, and we do accept that context is relevant to the clearest possible words, we don't seek to deny that, then that brings us to our alternative submission. But may I say that also that in support of the narrow construction, there are powerful arguments that have already been advanced by my learned friend Ms. Harrison about the unworkability and absurdity problems that arise as to enforcement. May I just address those a couple of points very briefly indeed, because I'm concerned to get to the alternative submission.
Of course.
And those are at paragraph 7
Yes.
of the roadmap. And I simply wish to draw your attention to a few citations. Ms. Harrison made the submission that detention under paragraph 10(9)(b) could not fall within any of the Article 5(1) exceptions. And if I can just show you the reference there, it's from Bid's skeleton. We set out the reasons quite fully why none of the Article 5 subparagraphs would apply in those circumstances. I also draw your attention to how the power of arrest works at 10(1). You've been showed 10(9), you've been showed 10(12). The power of arrest, which can be exercised by a police constable or an immigration officer, requires them to consider whether there are reasonable grounds for believing that a person may or has breached bail. And of course, we say in those circumstances, the officers carrying out the arrest are not directed to consider, understandably, particularly given some of them are going to be police constables, whether it would be lawful to make that arrest and then to detain the person under the bridging provision of 10(9). My Lord pointed out, and we entirely agree, that the most compelling point is, of course, 10(12), which requires the revival of the underlying detention power, which on the broader construction need not be there, so it's an impossibility. And one point that has not so far been mentioned is the alternative of criminal prosecution. And we say that's not a viable alternative in all circumstances for the following reason. Of course, it offers no control in respect of a bailee who has not yet breached bail, but is likely to, or even known to be, about to breach bail. It also, to adopt my Lord Justice Singh's phrase, risks an expensive and futile revolving door of prosecutions where you have a recalcitrant bailee who simply won't comply. They have to be prosecuted, potentially fined in prison, and re-prosecuted. We say that can hardly be Parliament's intention. But my Lords, can I turn now to the alternative submission? Yes. And that is heading D, paragraph 8 of our roadmap. No. And our argument, in a nutshell, is that statutory powers which may infringe on individual liberty require a particularly strict approach to statutory construction. The Singh limits are simply limits as to purpose, reasonableness, and reasonable necessity, as these apply in the particularly anxious context where the executive is given the power to curtail individual liberty. And could I ask you to turn up Tanti Lam, please, which is at Authorities tab 4.
Yes.
And if you could go, please, to page 44 of the Authorities. And could I draw your attention first to the indented quotation, which is from Mr. Justice who obviously then was in Harjil Singh.
Yes.
And although the power which is given to the Secretary of State is not subject to any express limitation of time, I'm quite satisfied it's subject to limitations, which he then sets out. I regard the power of detention as being impliedly limited to a period which is reasonably necessary for that purpose, and the period which is reasonable will depend on the circumstances of the case. And if I could ask you now, please, to turn to page 47 of the Authorities, where Lord Brown-Wilkinson states, and this is second sentence onwards, underneath the heading, the Harjil Singh principles, their lordships have no doubt. Could I ask you to read from there down to the end of E, so down to for unreasonable periods or in unreasonable circumstances?
Yes.
And then could I ask your lordships to turn, with apologies for the amount, bottom of paragraph 49, sorry, bottom of page 49, from G to H, their lordships do not exclude. And then could I ask you to go over the page down to B, so we're finishing at C per Lord Scarman at page 111.
This is all about detention, administrative detention.
Yes, my lord, but we say, and I'm going to come to that in a moment, we say that the same interpretative approach by virtue of B Algeria, in particular the passage of paragraphs 29 and 30 and 31, the same interpretative approach applies here. We say that the statute which you're asking this appeal to construe is precisely one in which the executive is given power to restrict human liberty, because the bail power, as has already been said, may be used to authorise restrictions which amount to imprisonments at common law, or even in extreme cases to deprivations of liberty for Article 5 purposes.
Presumably the logic of your argument, and indeed the appellant's argument, would apply also where the Secretary of State wishes to grant unconditional bail, because you would say that you simply don't have the power to grant bail.
My lord, that there is no power of unconditional bail
Well,
now.
there always has to be some condition.
Yes, if I'm right, I think it's paragraph 2 of Schedule 10 requires there always to be at least one bail. One condition.
Yes, I see. But could it be said by the reasonable member of the public that actually, in principle, the giving of bail is a benevolent provision, in principle? So let's say that they impose one condition, but it's relatively not very onerous. I don't know, whatever it is, whether it's residence or calling a police station once a year, or I don't know what it is. But let's assume that there can be a situation. You would say, as a matter of principle, the granting of bail, the granting of conditional bail, is to be treated in law as being similar to administrative detention, and therefore the Tante Lam principles apply.
Yes, my lord. And as to the first part of my Lord Justice Singh's formulation, I'm in the happy position of having the support of the Supreme Court in B Algeria, which said just that. So it wasn't a reasonable member of the public, but the eminently reasonable Mr. Tan, who made precisely that submission. Look, this is a benign power, and we use it to get people out of detention. Why would you restrict it? And the answer of the Supreme Court was, well, yes, there's a gamut of ways in which people can be granted bail, but the conditions that are available include those which may very severely curtail individual liberty. And in those circumstances, the court doesn't say, well, there's a plethora of different limits that apply depending on the circumstances. They say there is a single correct interpretation of these bail powers. Yeah. And we are saying, if we are wrong on the primary point, which is that the bail powers lapse if the detention powers can't lawfully be exercised, then there must, we respectfully say.
That's the bit I'm not following, I'm afraid. I understand your submissions in support of the appellant's ground one.
Yes.
And I understand your submission about how that's the effect of B Algeria. But I'm not, what I'm failing to understand at the moment is how ground 3 is a separate argument. We have to assume that ground 1 has failed.
Precisely, my lord. It's an alternative. So
how is it materially an alternative submission?
Well, my lord, let's take one hypothetical individual for whom there's a question about whether they can be removed within a reasonable period, for example. On ground 1, the reasonable period is to be judged on the basis that of what's a reasonable period of detention. So if the person cannot lawfully be detained today, because the Harjul Singh principles as they apply to detention have lapsed, you can't bail them either. That's the appellant's primary submission, which the intervener supports. On the alternative submission, the Harjil Singh limits are read into the bail powers. So one says, what is the reasonable period having regard to the fact the person isn't held in Harmondsworth, but is, for example, at large in the community, but subject to a curfew, whatever those conditions may be, having regard to the conditions, the duration, the fact that they're on bail and not in detention, what is the reasonable period? And the second alternative submission certainly comes into play only if the first one fails. And I would say it's less protective of liberty because logically, of course, the period that it's reasonable for a person to remain on bail is likely to be considerably shorter than the reasonable period vis-a-vis detention. So we're saying if you don't have, if the Secretary of State is right that there are the necessary clear and express words to achieve the expansion of the bail powers, so there's no limitation of power, no limitation of time as concerns the Harjil Singh limits on detention, then we say there must be implied limitations in the bail powers as to reasonableness, purpose, reasonable necessity. And that's the submission that I'm driving towards. So I've just given you an individual what would happen on two different scenarios. What if the first submission is accepted? What if the second submission is accepted? To take that to its logical conclusion, what happens if Mr. Tam's submission is accepted to that individual? The individual on Mr. Tam's submission can't come to court and say, my bail has been unreasonably prolonged.
Why not?
Or my conditions are not reasonably necessary. Because on Mr. Tam's submission, the only criteria, the only applicable principles are Hadfield and Wednesbury in their most denuded form. So what we are arguing for, and I hope in a moment to take you to the relevant passages in Lumbar, what we are arguing is simply that the Harjil Singh principles are themselves manifestations of Hadfield limitations and Wednesbury limitations as they apply in the particularly anxious context of the executive curtailing individual liberty. And we say, here too, we have a power that can be used to curtail individual liberty. Here too, the purpose of the power is ultimately to effect deportation or administrative removal or examination, as the case may be. The purpose is the same. The statutory interpretative approach is the same. We know that from B. Algeria. And so we say, if there are no limits of the primary sort, then implied limits must exist. But Mr. Tam says, no, you simply have a situation where the individual will come to court and say, you would essentially have to say, I'm being bailed for an improper purpose, or provided on Mr. Tam's case that the Kadir limit had not been reached, I'm being bailed for an improper purpose, or my bail conditions are perverse. And the court would effectively be limited to asking itself whether the Secretary of State's analysis of the facts was open to it. So instead of, as we have in the Harjil Singh line of jurisprudence, and it was, as was emphasised in Tanti Lam, the court saying, what is the reasonable period? The court itself formulates the view as to whether the boundaries of the power have been exceeded. On Mr. Tam's analysis, the court would be limited to saying, is the Secretary of State, is it reasonably open to the Secretary of State, for example, to conclude that these conditions should be imposed?
But that's what we normally do. I mean, the only legitimate basis on which the court can interfere with most public decisions is on the basis of well-known principles of judicial review, which include Padfield, and they include Wednesbury, or irrationality, if you want to call it that. The fact that some people might think that the decision is a harsh one is not usually a reason why we can properly intervene. So what's new or surprising about this proposition? Outside the context of administrative detention, for which, as you've shown to us, Tante Lam is all about administrative detention.
Well, my lord, let me put it this way. Say we have a curfew case, So the person is imprisoned for common law purposes. Jallo tells us that.
Right.
We say it's antithetical to the approach established in cases such as Tantilam and in Lumber, that where an individual is imprisoned, where the liberty of the individual is at stake, the court's supervisory function is restricted in that way. But can I try and come at this from another way, which I think may hopefully shed light on it? I'm going to jump forward, if I may, to paragraph 9 of the roadmap.
Yes.
I'm sorry, beg your pardon, not paragraph 9. To paragraph 12 of the roadmap. And this is the jurisprudence concerning proportionality as an implied limitation to statutory powers which impinge on fundamental rights. And can I stress that I'm not referring here, I'm sorry, I'm reminded I've got the wrong paragraph reference. It's paragraph 10 of the roadmap. I'm so sorry.
Right.
So I'm not referring here to the controversial question of whether proportionality should be recognised as a freestanding ground of review. I'm referring here, and that was why I started with Daly, to proportionality as an implied limit to certain statutory powers which impinge upon fundamental rights protected by the common law. Right. Could I ask you to turn up FAM, please, which is at tab 47. And could I ask you to look at 1213?
1213.
13.
Thank you. Yes, thank you very much.
And could I ask you to read paragraphs 118 and 119? Sorry, 118 to 120 actually.
Yes.
And could I ask you now on the same theme to turn up unison, which is at tab 53. And could I ask you to go please to page 1334, paragraph 80. And this is a judgment with Lord Reed, with which Lord Neuberger, Lord Mance, Lord Kerr, Lord Wilson and Lord Hughes all agreed.
So which paragraph?
Paragraph 80. Even where statutory power authorises an intrusion upon the right of access to the court it is interpreted as authorising only such a degree of intrusion as is reasonably necessary to fulfil the objective of the provision in question. And I'm emphasising the words reasonably necessary because it will be recalled those are precisely the same limits which we saw earlier were read in by Mr. Justice Wolfe as he then was to the detention power in the case of Harjot Singh. And then at the indented quote just above paragraph 81, Lord Reed cites Lord Justice Steyn, I should say, as he then was in Leach. The authorised intrusion must be the minimum necessary. And then paragraph 80 is the passage in Daly that I gave you earlier. And then could I ask you to look, please, at paragraph 88, which is Lord Reed's encapsulation. Even where primary legislation authorises the imposition of an intrusion on the right of access to justice, presumed to be subject to an implied limitation, the degree of intrusion must not be greater than is justified by the objectives which the measure is intended to serve. And then over the page, even an interference with access to the courts which is not insurmountable will be unlawful unless it can be justified as reasonably necessary to meet a legitimate objective. And we say that the right to liberty, which is at stake when construing the bail powers, is just as fundamental in the common law as the right to access to justice, which is under consideration in these cases, and that the same approach applies of saying if Parliament has authorised the intrusion, that is only to the extent reasonably necessary. And the Singh principles were, I've given you the references actually in the roadmap. It's said in Lumba by several justices of the Supreme Court to essentially being manifestations in the detention context of Padfield and Wednesbury. But another way to look at Singh, of course, is to say that it's a requirement of reasonable necessity. And that is what we are contending for here. We say that there is nothing unorthodox in this. What is unorthodox in our submission is the Secretary of State's contention that there are no implied limits as to time, as to reasonable necessity, as to proportionality, or as to the Secretary of State having to carry out her functions with due diligence. Could I ask you to look now, and I'm now turning to paragraph 12 of the roadmap, could I ask you to turn up Bid's skeleton in the core bundle at tab 7. And this is page 96, where we set out what we say.
Can you give me the paragraph number?
I'm sorry, yes, it's paragraph 34 of Bid's skeleton argument.
Yes, thank you very much.
And we set out here how this alternative submission concerning implied limitations works. We say the bail powers can only be lawfully exercised for the purposes of effecting deportation or removal. They can only be lawfully exercised for the period which is reasonably necessary for that purpose. And I should say, don't understand that to be accepted by Mr. Tam. The second of those limitations, our understanding of the way Mr. Tam's construction of the bail power work, is that this does not apply. And the reasonable period here is ascertained by reference to the fact that the person is on bail, not, as in the first submission, the reasonable period of detention. And then the third limit, and this is, again, a close analogue to the Singh principles as they apply to the detention powers. A person can no longer be lawfully exercised once it becomes apparent that removal or deportation will not be achieved within a reasonable period. And the Secretary of State will be required to exercise all reasonable expedition to effect removal or deportation. These last two we also understand not to be open to the bailee on Mr. Tam's construction. So the bailee, a vulnerable bailee for whom there was some prospect of eventual removal. Sorry.
I don't find it surprising that Mr. Tam doesn't accept, for example, your third suggested limitation. That makes perfect sense, he would say, where somebody's being administratively detained. But the whole point is that this person is not being administratively detained. For example, they can, in principle, they can go out to work, subject to a condition about work. But what I can well understand your point about having conditions which are only reasonably necessary to achieve their purpose. I can understand that. So, for example, if the fear is that somebody will abscond,
yes,
then you might have a residence condition. You might have a report to the police every week condition. I can understand that. But suppose there was no evidence that there was any risk of absconding. then it might be said that such a restriction is not reasonably necessary. So depending on the facts of each case, I can see the submission you're making in principle. But once you start saying that there's no power to have conditional bail, once it becomes apparent that deportation will not be achieved within a reasonable period, that's not a limitation about the condition being reasonably necessary to achieve its purpose. That's some other limitation coming in.
Well, my lord, so that's reasonable necessity as to duration. So if you on this, and if I could run together the third and fourth point here, on Mr. Tam's analysis, as I understand it, you could have a person on curfew in circumstances where perhaps there is still some prospect that they will eventually be removed.
Yes.
But they cannot come to court, even though their bail may last years. And that is, of course, the situation that arises in this case, and as Mr. McLuce's witness statements shows forbid, that's something that has also arisen in other cases where people spend years on bail, which may include draconian limitations on movement, on liberty. But they can't come to court and say, this has gone on longer than reasonably necessary, where reasonable necessity is not looked at by reference to some hypothesis where they might be detained, but looked at by reference to how long are they on bail, how intrusive are the bail conditions, what is the impact of the bail conditions on this particular individual. So we do say that it's something that to go back to Tanti Lam, the courts should be slow to accept, we respectfully say, a situation where somebody could, for example, be on curfew for years, but not be able to complain that the duration was longer than reasonably necessary, having regard to, for example, their vulnerability, the fact that they were on curfew, the impact. Or, for example, might have a situation where the Secretary of State was being grossly dilatory in effecting removal or deportation, but still retained that purpose. And we say this too, by analogy with the Singh principles as they apply in detention, this too must be something that somebody is able to come to court and say, the reason why this is going so long is the Secretary of State, for example, is doing nothing about trying to document me, and it's outside my power to do anything, or a hypothetical scenario. So, and we do say that because personal liberty can be so severely curtailed by these powers, it is absolutely right that, as in detention, the court should be able to ascertain for themselves whether the limits of the power have been reached, in the sense that, for example, a curfew is not reasonably necessary, or the duration is not reasonably necessary on the circumstance of this case.
I find it, speaking for myself, I find it very difficult to have this kind of debate in the abstract. This is why the method of the common law is to decide particular cases on concrete facts. You may be right, I don't know, that one day somebody will come along and say, I'm subject to a curfew, this has gone on for 5 years, and really it's long enough now. But somebody else may be subject to a very light condition. But your argument would have to be the same, wouldn't it? That once it's become apparent that deportation will not be achieved within a reasonable period, then it's no longer reasonable to put them on conditional bail.
Well, my lord, if somebody's under 24-hour house arrest, then the reasonable period will be shorter than the person who's required to...
But that's why I suggest, with respect, that one may have to look at the concrete facts of an individual case. Here, these are not the facts.
My lord, I entirely accept. I mean, when I give you the example of curfew, it's to show you the unattractive consequences of a Secretary of State's submission, that there are facts before you. Of course, it's not for us to make submissions on Mr. Kaitey's facts, but the appellant's case, as we understand it from their skeleton from their grounds of appeal, is that the reason, in the alternative, they adopt bids alternative submission and say in the alternative, it's gone on longer than is reasonably necessary, having regard to all the circumstances of his case, including the fact that he has been, as we understand it, on bail or in detention or on restriction of some form or another since 2011. And of course that would have to have regard to the particular type of restrictions. So, my lord, I quite accept you wouldn't decide Mr. Kaitey's facts on the basis that he was on curfew. He isn't. The reasonable necessity is always an elastic concept. It's fact specific. But the court is not being asked to determine this question in a vacuum. This submission is adopted by the appellant, who says, if I'm wrong on primary submission, this has gone on for longer than reasonably necessary.
Right, okay, well, we understand that, and I'm sorry that we've had quite a few questions for both advocates so far, so you're very close to your time limit, if indeed you haven't already gone slightly past it. Is there anything else that you need to add?
Unless I can assist the court.
Can I just check with my lords if there's anything? No, we don't have any more questions for you. Thank you very much. Mr. Tam, how are we doing on the agreed timetable?
Well, I think that the reality is we're about 25 minutes over.
Right.
It's not, can I say, it's not a problem for me because I have the luxury of being able to refine overnight what I say. And if the court will forgive me doing a certain amount of headlining tomorrow, then I think we can get back on track without much difficulty.
Right.
But if it will help for me to make a start this afternoon, I'm happy to do that.
The alternative is that we could sit
I can sit at 10. I think it's better that you should have the
Should we let him refine overnight? Start at 10. Mr. Tam, thank you for that offer. We think, on reflection, that the best course might be, subject to your availability, if we could sit at 10 o'clock tomorrow. Would that be all right?
Certainly, it's fine for me.
Right, I see others are nodding.
Yes, Lord, that's
Yes,
sensible.
that might be the best thing then for all concerned, and that'll give you the chance to refine your thoughts overnight.
Lord, yes, and I'll be as efficient as I can tomorrow.
I know. All right, we'll resume at 10 o'clock tomorrow.
Well,